Hello guys, this is me Durga Bhatt and today I am going to explain about quasi contracts and here are the contents which I am going to explain. Generally, contracts are made by the parties and the rights and obligations are created by themselves against each other. However, there are certain kinds of contracts which are imposed upon a person by the courts and the rights and obligations of such kind of contracts are governed by the laws of the land. Such contracts are known as constructive contracts or simply quasi-contracts under English law. Now, let us discuss how the term quasi-contract has been explained under Indian law. The Indian Contract Act does not use the term quasi-contract for such obligations. However, it describes quasi-contracts as certain relations resembling those created by contracts, which means it is an obligation which the law creates in the absence of any agreement. Quasi-contracts are based on the maxim nemo det lacto plateri ex linea justua, which means no man should grow rich out of another person's cost. Or in other words, it is based on the equitable principle which states that no person should be allowed to enrich himself at the expense of the another person. Now, let us discuss what are the characteristics of the quasi-contracts. Firstly, quasi-contract is not a real or a true contract but an obligation imposed by law. Secondly, it is not created by any agreement but it's a creature of law. Thirdly, it is not based on express or implied intentions of the parties, rather it is contrary to the party's intention. Fourthly, quasi-contract arises from the duty of the party and not the promise of any party. Lastly, quasi-contract always gives rise to right in personam and not in right in rem. Now, here comes to the important part, that is, the quasi-contract has been divided into 5 different parts from Section 68 of the Indian Contract Act to Section 72 of the Indian Contract Act. Let us begin with the first part, that is Section 68, which deals with supply of necessities to the person who are not component to a contract. Sometimes a person supplies certain necessities to the person who are not component to a contract, such as a minor or a person of unsound mind. Under such circumstances, the person supplying the necessity is entitled to recover back the goods from the property of the incompetent person. Let me explain this with an example. A supplied certain necessities to B, a lunatic, based on his living conditions. In this case, A is entitled to recover back the necessities supplied by him through the to the property of the incompetent person. Now, let us start with the second part, that is Section 69, which deals with payment made by interested person. Sometimes a person makes the payment which is a legal duty of another person. Let me explain this with the definition as it states, a person who is interested in the payment of money which another is bound by law to pay and who thereafter pays it is entitled to reimbursed by the other. Let me explain this with an appropriate example. A held the land on lease granted by B, a zamindar. Later, the revenue payable by B fell in arrears, which the land for advertisement for its sale by the government. Under the revenue law, the consequences of such sale led on the annulment of A's lease. In order to prevent such consequent annulment, A made the entire payment on behalf of B. In this case, A is entitled to recover the entire amount from B, and in the same way, B is also bound to make the entire payment to A. Now, let us discuss the third part, that is Section 70, which deals with non-gratuitous acts. Here the term non-gratuitous means any act which is not done for free. Let us discuss this with the definition as it states as, where a person lawfully does anything for another person or delivers anything to him, nor intending to do so gratuitously, and such other person enjoys the benefits thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. Let me explain this with an appropriate example. A tradesman, left certain goods at B's house by mistake. B treated the goods as its own and used them. In this case, B is entitled to return back the goods or repay the amount of the goods. Now, let us begin with the fourth part, that is Section 71, which deals with finder of the goods. Firstly, let us begin with the definition. A person who finds goods belonging to another and takes them into his custody is subjected to same responsibility as a bailiff. Sometimes a person finds goods belonging to another person. Under such circumstances, the goods does not become the property of the finder and the law imposes certain obligations on the finder, such as he must take care of the goods as much as an ordinary man would take care of his own goods. Here comes to the last and the final part, that is section 72, which deals with payment of money or delivery of goods by mistake or under coercion. Let us begin with the definition first. A person to whom money has been paid or anything delivered by mistake or under coercion must repay or return it. Which means sometimes a certain amount of money is paid or something has been delivered to a person by mistake or under coercion. Under such circumstances, the person receiving such amount or goods must repay or return the same to the person who has paid or delivered by mistake or under coercion. Let me explain with an appropriate examples. Firstly, A and B jointly owed 100 rupees to C. A paid the entire amount on behalf of both A and B to C. Without knowing the fact that A has already paid, B has also made payment to C. In this case, C is bound to repay the amount to B, who has paid the amount by mistake. Even in case of coercion, it is similar. The money paid under coercion can also be recovered back, which has been clearly explained under section 16 of the Indian Contract Act. Thank you guys. Thank you so much for watching this video.